Unless she's lying to me, stop, or I'll hold you in contempt.
Just to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me. Sit down. You're done speaking today.
To be fair, Judge.
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. He was being lazy and unprofessional, counsel. He never spoke to the defendant. All right, appearances for People versus Littleton.
Morning, Your Honor. Elizabeth Moore on behalf of the people. 84724. Good morning, Your Honor. Attorney Sahar Cross and Attorney Martin James Case, hearing on behalf of Mr. Littleton. Mr. Littleton, can you please issue the order?
All right, ladies, we ready to go?
Yes, Judge. The people are ready to go, and I have a complaining witness who flew in from out of the country to be here today.
All right, put her on the stand.
Your Honor, I mean, Mr. Littleton, to refer the competency at this time, the defense counsel is adamant that Mr. Littleton is no way understanding the nature or the object of the proceeding and cannot. He is not fully aware, Your Honor, when I try to ask him or explain to him that I'm his attorney. He doesn't.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So it was the first one that it was a little off. If Your Honor was I'm not sure if Your Honor was the judge at that time.
Was not.
That I didn't think anything.
Counsel, my question was a simple one. When did you know you had this problem?
So I'm telling you it's a compounded issue, Your Honor. It wasn't just the first time, it was the second time also.
Denied. Denied. Twice I've asked you a direct question, you can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today. I didn't ask for an argument, counsel. I just told you my decision.
Going to be completely, I think to be ready and what to be administered. Mr. Wilson, I have not opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Ms.
So schedule a show cause for Attorney King for contempt of court. Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?
Understanding when there is a different environment that he's explaining to us because I was going to come here anyway, and because Mr. Littleton was going to refer to competence.
No, he wasn't. No, he wasn't. You were going to ask for that.
The court, the statute requires that the court at least consider that the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear, and if Mr. Littleton cannot assist rationally, cannot comprehend what is actually happening, actually he cannot move forward. And I think the court has an obligation to consider what.
Here's what I consider. Here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled, that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not doing. Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record, if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Ms. Barrage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. I don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at. No.
Judge, I contacted Mr. King. I called NDS last week
contacted them specifically so that I could figure out ahead of the PCC who the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the probable cause conference. I let him know that I was personally sending him the digital discovery so that he could review it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring for competency. I also let him know that I spoke to the out of the country complaining witness, confirmed the next 4 to 6 Wednesdays her free in her schedule, and let him know that we'd be flying her in, and told Mr. King that I would make any of those days work, but that if we scheduled an exam for her to be flown into the country, and Judge, this is very important, this happened at the airport, so flown into the airport, that she was sexually assaulted in, that if that happened, and if she came here, we were holding this exam. Because I was not going to have the victim come all the way back here, only to be told that there was an adjournment request or have him be referred for competency. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized it was pre-PCC. The PCC happened. I appeared early. I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge meet her where her plane landed at the actual gate to get her from the gate through the airport. Again, she was sexually assaulted into her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave to come here, just to confirm that he was not planning on asking for an adjournment for discovery, to confirm that he was not planning on referring the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him, and that they were concerned about his competency, and that he wasn't sure if the defendant would be able to sit through with this hearing staying.
This is totally unconscionable.
Which I told Mr. King that we would address the, because to be fair, Judge,
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Clear? Make sure he brings a toothbrush when he comes for his show cause. Thank you.
if I may, Judge, I recognize I have no actual power to object to a competency referral. And I recognize that. But the way that this was handled, it is one thing to inconvenience me, and I have a lot of respect for the Neighborhood Defender Services. There are several of them here at this courthouse that I have so much respect for.
Me too.
But how this was handled was completely inappropriate, and I told Mr. King that until there was an actual issue in court, we were here, we were ready to go, and I'm at a loss, Judge, because ethically as a prosecutor, I know that I cannot push to proceed when there is a genuine referral for competency. I don't want to compromise my ethics, but this is extremely difficult for the position that we are in, and the reason we're in this position is because of Mr. King.
If I may, Your Honor. Yeah.
Go ahead.
Well, thank you, prosecutor, for the procedural history, and I can't speak to the conversations of the prosecutor had with Mr. King directly. However, I will remind them, or just say, that at the times and moments that Mr. King was stating that he did not intend to refer to competency until after buying over, that those were true statements, and it wasn't until understanding the actual, and not to get into privileged communications and client confidential conversations that we've had, that even at this preliminary examination, even if it is probable cause, and even though he's told the prosecutor that we don't intend to refer to competency until later, it was clear that Mr. Littleton has an issue understanding the order, nature, and proceedings, as well as not being able to assist rationally in his defense. So it's not to say that Mr. King wasn't being honest or truthful, but
He was being lazy and unprofessional, counsel. He never spoke to the defendant.
Your Honor,
Unless she's lying to me, King told her he'd never met with Mr. Littleton. Other people from his office had.
I wasn't part of that conversation. I can't speak to them. I'm not
Then I'm going to take her at her word.
lying. Just saying that all the other times that she was speaking with Mr. King and he made the applications and the intention of holding this exam, that was his intention. It wasn't to be dismissive. He wasn't refusing to communicate, that he was figuring out.
Counsel, Stop, 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 stop,
Right.
stop, or I'll hold you in contempt.
Just to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me. Sit down. You're done speaking today.
Done speaking today?
Yes, ma'am. Who flew in?
Judge, the complaining witness in this case, her name is Nora Al-Thamna, that's spelled Noura, last name AL dash.
All right, I'm going to want her in here in just a minute. Do the paperwork so we can send Mr. Littleton for his competency, which will be 6 months down the road before we hear anything. You guys can take Mr. Littleton back into lockup. Bring your complainant in. What's all being right?
Judge, do you want to come up?
Please,
All the way up?
just podium, yeah. Right here, ma'am. Right here. Did you tell her what happened?
I did not. I told her that there was an issue and he wanted to see her and that I would explain after.
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly with documentation to counsel what it costs you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs. You understand that? All right. I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because the system is not treating you well. Thank you, counsel.
Bring it.
Ms. Moore, anything else?
Thank you. And again, I just want to acknowledge that I do not believe that Ms. Farage did anything. She was just sent.
I don't disagree. Thank you. What's next? What is it? This one?
Mr. Martin.
Hey, man.
Go ahead.
Good morning, Judge Oakley. Good morning, your staff. Neighbor Defender Service, Carrie Martin, P 84592. I'm gonna have my client, Mr. Vontae Mack, who stands to my right. Vontae Martinez.
Thank you. All right, waiver?
Yeah.
All right, Mr. Mack, you, or Mr. Walker or Mack?
Mack.
I got a Walker file.
Yeah, that's my line. She probably needs.
All right, so where's the Mack file?
Never pulled it.
I thought you just told.
File, so I have names for my people. I'll make them.
M-A-C-K?
Correct.
Vontae. Go. Waiver. All right, sir, you understand your rights and options?
Yes.
And you understand the purpose for the exam?
Yes.
You understand that a waiver means the file goes downtown? Won't be at the district court level where you're at now. It'll be downtown circuit court. And understanding all of that, you want to waive? Are you doing so freely and voluntarily? Counsel, are you satisfied?
That's fine, Judge.
So am I. AOI date will be the 13th. 9 a.m. Give me a minute and you fellas can sign. Mr. Mack, looks like you owe us $824 on 2021 Huron Township civil infractions. What can you do about that?
Yeah.
Half today? Go downstairs and make arrangements for the rest. Joe, signatures? Are we ready on Walker?
Yeah.
Come on up.
Richard's is waiting on the phone. Dennis more about prepare for, she's.
Ms. Richards, you're up next on Dinsmore. Counsel, your appearance for Walker.
Gary Robinson, P 71733, on behalf of Ms. Walker.
What are we doing?
Our attorney, Ms. Brown, we need digital discovery. I do have the paper discovery. Mr. Muhammad did send an email over to the officer in charge requesting that digital discovery be turned over. We're gonna move it all possible.
2 weeks?
Yes. Patricia,
Patricia. What time you want to do that on the 13th? That's for Judge Martin or Judge Patton? 10:15? 10:15? Okay, all right. You, ma'am, just have a seat. We'll get you a notice, paper notice.
13th at 10:15.
Yes, ma'am.
Khalil Smith did not appear according to the court.
Khalil Smith. All right, he's in the bench warrant pile.
Thank you, Your Honor.
Miss Richards on Dinsmore?
Your Honor, I believe there's a reference from
Yeah.
It's. Your Honor, today was set as a competency review.
Yeah,
Internal review, so I can look for people.
yeah.
Taken off one thing go.
Oh, okay. I didn't realize the court was, I apologize to the court for that.
Right. I think I overheard the conversation.
Right. I don't know if the court remembers who says.
I remember we did it. I just looked at the notes. We did it on the phone. We ordered competency on the phone. Yeah, Zoom.
She's in her.
Yeah, we put her on a speakerphone. Yeah.
So the situation with what happened with her missing her competency review is the forensic center requires that they either appear in person in Saline or they can appear on Zoom, but in a professional setting. Ms. Dinsmore lives in Waterford, and my social worker was trying to coordinate with the location, the facility that
Right.
to find like a conference room.
Yeah.
And was just unable to do so. He was in touch with the forensic center trying to coordinate. We tried to ask the forensic center for more time.
Mhm.
They said they couldn't do that. So ultimately, what I'm asking is if the court.
You want another date?
Yes, recall the warrant and try to coordinate this. It's just very difficult to get people that don't have resources. Either to our office or to Saline.
You need to buy a little mobile van, little mobile office van, right? All tricked out for Zoom that you can go where you gotta go. I doubt it, but it would work, right? You would probably avoid a lot of lost time.
Right.
All right, you're welcome. Miss Richards.
Yeah.
She is one.
She almost had come for an apartment. That's great. I am. Insurance. I mean, taxes. Just like, no, what do I? And then for the record that we didn't have time. It's already meeting. Now people are. Yeah. That was because. Well, but I think it's simple. Yeah. Right. He was. I mean, that's why I get it. It's something.
Yeah.
Usually it's either you were a civil attorney, you're learning, or. That. I'll yeah,
Well, no, which is,
so.
I'll have Joe take the notice out. Thank you.
That's possible.
We're gonna live lunch. I'm the one.
What was it?
Yeah, what anything else?
No, I guess, oh, you like to do it all. Okay.
Oh, because he's got a few last, I gotta do a piece here.
Yeah, building of our trial, and then whatever Muhammad has. Two. That's what we're running with.
Oh, okay.
Unless. you
I'll
guys-
go with Mr. Mays and that's gonna be.
Yeah. I might get one. Although, the, yeah. It's not really, I'll be great.
Go get your lunch. And then we'll talk about your thing. Where are we all with your German? Are you not sure?
I'm done, yeah, well, besides city council, but we don't have an attorney.
Oh, I don't need to share. Because he's very rich. Oh,
Absolutely.
oh, sorry.
I'll get it.
So for any vote, you guys have it.
I don't believe there's a voice in service.
I'm not there.
Dang.
For the years.
Oh, yeah.
Yeah. Last minute, I mean, just scheduled it last week.
But we get the first two. Yeah, but he's got the last one. I mean, especially if he finds, and that's an issue. I mean, if they made the delay, they.
Where do you first one?
Until I go to the judge, I'll be like, the same, I'll just be doing that.
Yeah.
She shouldn't. It's
Yeah,
a position. The guy has never met with it. I think so too.
I can. Crime and ethics lessons 2 weeks in a row. I mean, he did that. To us. He's still doing it.
There was some.
Yeah, he's apparently getting hired by
There's
some
nothing
other
for-
firm.
You.
I don't know.
Oh, good for him.
Yeah, I don't know how.
Well, I tell somebody, you want to read it, back in
Wait, wait, wait. It was, I don't know if back in the day, the court appointed attorneys can get credit.
Yeah.
I really think they're making pretty.
They think all the same, not more than we.
Watch it.
Yeah. Oh, Indians for sure. Indians for sure.
All DC, case over from IDC, work less than 40 hour week and replace myself.
I mean, I could never, I don't, but I could.
And don't get me wrong, we got some really good attorneys in that system.
Oh, yeah.
Yeah, sounds great, John.
Oh, he was up here today.
Shut up.
Him and his
He
client
did,
got up here for their, or maybe his client came.
I think.
His client's been here since 9/18 this morning.
Did anybody call?
Oh, that was, I got just.
Yeah, for in person.
Some,
Yeah,
Yeah.
usually you talk somebody else into cover.
or
Yep, his
up here.
client. It's not a client.
Just drives me out.
No.
I haven't.
I can do it.
Well, we don't have a lot left over from the morning.
No. I know, we ran today.
Ran.
I don't know how many games you guys got.
1, 2, 3, 4, 5, 6, 7,
Oh. Well,
and then 2 trials.
one trial.
1 trial, 1 motion.
I got your trial done. The other trial's gone.
Yeah. Graziani. Same.
Finished. We're going to get much.
All right, better go before we start things off.
I know.
I can put it back. You're gonna put it back. Yeah, okay. All right, thanks.
So.
It's terrible.
Um,
Oh my God. Did they, figure out what they're doing with that?
yeah, I heard. Yeah, I mean, it's gonna be the same looks. We.
Hey, can I check a couple names from this morning docket to see if they showed up? Yeah, can you, I got a couple names I want to check from this morning, see if they showed up. I'll just tell you, I got a handful of files. Darian Bibbs. Yep. Yep, BIBBS. How about Davis, Ishmael or Ralph? How about Ralph Davis?
Yeah.
Did show. All right, next one is Sadine Hawk, HAQQ. All right, Heather says he's here.
Okay.
Lavish Towing.
This meeting just. There's a telling you.
I don't even film on my docket, though.
Okay. How about, James Patterson?
First and final pre-trial, vote with Martin.
Myron Williams.
Are you speak to you?
Joe. Got files?
Are you ready? Yeah.
Thank you.
You repeat yourself. Sorry. He wasn't aware that was a banner down. Yes.
We had a case at 11 Littleton.
Sellers?
Yeah, it was called
Counsel, your appearance for cells.
larceny.
That, no, Your Honor, arbiters, it's gotta be adequate of officer rules.
Yeah, and so
Sills, got it. Mr. Sills, state your name on the record, please.
larceny.
Thank you.
Oh, sorry.
On the record. Counsel, what are we doing today?
I have this, very examination, my climate is.
Thank you. Mr. Sills, do you understand your rights and the options those rights give you? Do you understand the purpose for a preliminary exam? You understand that if you waive the exam, the case goes downtown for the next court date at the circuit court level, not at the district court where we're at now. Understanding that, you're gonna waive? And you're doing so freely and voluntarily? Counsel, you satisfied?
Yes, Your Honor.
So am I. AOI date is 2 weeks down the road at 9 a.m. on the 13th. I'm gonna sign some stuff in here and then I'm gonna hand the documents to you guys to sign. I will continue bond. Mr. Sills, I wish you luck downtown. Sure.
So Judge, Mr. Littleton had another case, larceny in a building from the airport. Are we still gonna call that case?
I called them both. I thought they were all together. Weren't they both scheduled for exam at the same time?
Yeah, so one was a CSC and the other was a larceny.
I had
was
the
a-
files together. I just called.
Oh,
Doesn't change anything.
no,
Competency on one, competency on both. Same defense attorney that wasn't here.
I understand. All right, I'll let him know.
Yep.
Thank you.
This one needs to just be dismissed, Judge.
I can do that. How come?
The computer. Here's real quick, he showed.
Good.
That's not.
Good day, Bill.
Can we do these in October since the other 2 dates are already full? Or no?
Let's ask. Your appearance for Mr. Davis.
Mr. Davis, please.
Ralph Davis.
Again, Judge, John Contempt, attorney on behalf of Ralph Davis. Judge, we're simply requesting a trial on this matter. I wanted to put it off for one more.
All right.
One more pre-trial, but,
We sent it for a bench trial?
what do you want, bench or jury trial?
I don't even know why I want to try anything, Your Honor, because I don't know nothing about this.
Okay, well, I'm assuming because the prosecutor's not willing to dismiss it today.
Well, from what they said, they have video of me doing this incident.
Okay,
They haven't produced it or with
okay.
it, so
Well, they don't have to produce it until trial.
I'm I'm not used to all of this.
Okay, okay,
Judge, I think it's really trial.
Taking
Yeah.
it.
yeah.
I did indicate, Your Honor, that we'd be in a position to possibly resolve this in a part of that, but for having expediency in this court, we have to.
Put a date on the, yeah, put a date on the calendar. So do you understand the difference between a bench trial and a jury trial?
No, I do not.
All right, well, let's take care of that. With a bench trial, I'm gonna use me because it's my file. With a bench trial, I'm gonna listen to all the testimonies, look at all the evidence, and I'll make all the decisions, either factual decisions, did this happen or did that happen? Or legal decision, does this law apply or that law apply? They're all my decisions to make. Understood? With a jury trial, I'm still gonna make the legal decisions. I'll still decide what law applies to the case, but the jury will decide, did X happen or did Y happen? The jury's in charge of the facts, I'm in charge of the law. With a bench trial, I do it all. The other difference is a big one, is time-wise, right? Bench trials are always faster than jury trials because there's a lot less people involved. The process is more streamlined. Do you understand the difference between the two? You want a bench trial or a jury trial? All right. What's our October date, Heather?
It is October 15th.
Judge, I may be out of the country at that time.
Good for you.
Possible. in
10/22. Is he back?
Maybe another week, I apologize again.
That's gonna get it, probably get us into December.
End of November,
Okay, what's our November date?
26.
Thank you.
Time.
11 a.m.
All right, so we're gonna get you a paper notice for that date and time. Go ahead, Mr. Mohammed. Bench trial. Yep. And Mr. Davis, you have another case coming up on August 28th. You know about that one? Trespassing? Okay. All right. So if you have a seat, we're gonna get you a notice for that jury trial or that bench trial in November. Just have a seat. You're welcome. Let's see, Joe Taylor. Come on up, Mr. Taylor. Mr. Graziani.
John Husk, I'm here on behalf of Joe Taylor, Judge. Please identify yourself, sir.
Thank you, sir. What are we gonna do? Set a bench trial on this one? Or set a trial?
Listen, you heard what Judge Oakley indicated during the bench trial, possibly under your circumstances, you may ultimately up to you.
It's your call. Yeah, first of all, you understand the difference between the two? Okay, all right.
Really short. Yeah, I'll go bench trial.
Bench trial? All right, let's do it the same date. November 26th. Let's set them both at 11 o'clock.
Can you arraign him too, please, Judge?
Yeah, would you waive formal reading?
Yes, Judge, wait the formal readings.
All right, are you gonna try to talk me out of a personal bond for Mr. Taylor?
I certainly will not. Judge.
All right. Mr. Taylor, are you working?
Yes,
Where do you work? How long you been there?
drive, actually,
Who do you drive? Who do you drive for?
I just deliver packages.
Good. Okay. All right, I'm gonna put you on a personal bond. The first condition is the obvious one, stay out of trouble, right? Don't go out and crime spree. The second one is show up for your bench trial November 26th, 11 a.m. And the third one is do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. Can you live with those rules?
Yeah.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond? Put your hand out. Now, we've got some other stuff, looks like you owe us money on. Yeah, distracted driving, no proof of insurance. Are you in a position to commit to some kind of regular payments to take care of those?
I'm in a position for that, but I'm just not in a position. Some today.
No. Yeah, but you can set up a payment plan.
Yes, sir.
All right, do that before you leave the building, downstairs at the front counter. Questions?
No.
You're all set? Have a seat. We'll get you a paper notice. Counsel, there's a civil infraction. We'll just let that tag on with a. Thanks, all. All right, gentlemen, what do we got?
Melon Warren, ready to pull an exam.
All right. You can have a seat. They train the attorneys to jump up when they talk to judges. Your appearance, counsel?
I can't believe I have to keep doing this. Those words summed up the judge's frustration during one of the toughest probation hearings of the day. Tyler Tillery appeared before the court after repeatedly struggling to comply with the requirements of a sobriety court program. Before anyone else spoke, the judge made his feelings clear. He said Tyler constantly complained about probation requirements, questioned why he had to undergo frequent testing, and acted as though the court was asking too much of him. The judge reminded him that he had already picked up 2 alcohol-related offenses before turning 21, yet still didn't seem to understand how serious his situation had become. Defense counsel tried to highlight the positives. Tyler had maintained steady employment, wasn't testing positive for alcohol, and appeared to be making progress in some areas. His attorney admitted that perhaps he should have provided more guidance earlier in the process, but emphasized that Tyler was still young and capable of turning his life around. The judge listened patiently, but pushed back. He explained that simply avoiding alcohol